Collection of Charles Waddie, also known as Thistledown's Correspondence. As Charles Waddie, the Honour Secretary for Scottish Home Rule Association, Article 1 of 8, as taken from the Scotsman, dated Tuesday the 16th of February 1886. Home Rule. Sir, having in my former letters discussed some of the general bearings of this great question, it may not be amiss now to consider what effect Home Rule would have upon Scotland and her capital. Let me ask them, does Scotland need Home Rule, and do the people want it? If you do not think your readers are weary of me, I would like to address them on this subject as briefly as possible. Having been a careful observer of public affairs for over 30 years, I have no hesitation in affirming that Scotland most urgently needs Home Rule, paradoxical as it may appear, even more so than Ireland. This opinion is based on the fact that the history of our country, its manners and customs, laws and institutions are distinctly different from England, form a more complete contrast than English institutions do to Irish. The criminal law, for example, with its public prosecutors and jury trial. In Scotland, a majority of the jury carries conviction, but in England and Ireland the jury must be unanimous. An absurdity to a logical people like the Scotch, where 12 men hardly ever could agree upon anything. With such a system, the marvel is how any criminals are convicted at all. In England and Ireland, the jury have only 2 verdicts, but in Scotland they have 3, which is also in harmony with the prevailing sentiment of the people. It is not the Scottish law, be it remembered, that is odd. Our laws are founded on the same principles as the jurisprudence of other European states. It is the English that is peculiar and unsuited to us. Then, if our laws are worthy of being maintained, it follows that we must not starve our superior courts, but bring everything we can into them. For being a small people and requiring to keep an efficient bar, if the richest part of the practice is carried to London, our advocates will be impoverished, and the best of our lawyers will leave a country where the most lucrative part of their profession is given over to strangers. I need say no more on this point, it is self-evident. If private bill legislation were managed in Edinburgh, a number of very considerable advantages would accrue to Scotland. In the first place, any expense incurred would be given to our own people and serve to maintain the efficiency of our bar. The cost to the promoters would also be very much smaller, for legal talent could be secured for 20 guineas here, which would cost in London from 50 to 100. For parliamentary lawyers are there overgorged with prey and are negligent and saucy to a degree. Moreover, the greater proportion of the population of Scotland being within easy distance of the capital, parties interested in private bills could be called by telegram when they were required and return the same evening to their homes. The result of this arrangement would be that private bills would cost about 1/4 what they do in London, and the costs could go to enrich our own people and not be squandered upon strangers. Scottish lawyers may also be credited with a knowledge of Scottish wants unknown to English barristers. It is in public legislation, however, that Scotland has most cause of complaint, having only 70 representatives in a House of over 600. She is left entirely at the mercy of the English members, who, having consumed the whole available time, thrust Scottish business into the small hours of the morning. It is impossible for our business to be properly managed at these unseasonable hours. It is worse than an insult. It is a cruel injury to have our laws and institutions mangled by sleepy legislators. How different would things be if the members sat in Edinburgh under the eye of Scotland? Not a drowsy hour at midnight, but a whole summer's day would be spent in providing us with wise reforms. Is there a man in Scotland who cannot see the immense advantage of Home Rule in providing us with wholesome laws? Now, though we are a small people, we have a great past, and I trust a great future. The variety of our needs are as great as England's, and will give ample works to a Scottish Parliament. If, then, the laws of Scotland were amended in the country, our nobility and gentry would be compelled to reside in the capital, and the millions that are drained from Scotland would be spent at home. It is the highest testimony to the amazing industry of the country that she has been able to stand this drain on her resources so long. But there is a sense which, to the generous mind, will commend Home Rule more than the saving of wealth, and that is the retaining at home our own men of genius. The Royal Scottish Academy is starving by having her best members drafted to London in search of patrons which, if Scottish wealth was spent at home, would be found at their own door. Edinburgh would become indeed a royal city, a second Paris, but not second to her in beauty. Society being enriched by a real nobility and gentry would at once extinguish that narrow professional caste which is sometimes referred to as the reproach of Edinburgh society. Literature and art would follow, music and the drama would rise to a level worthy of the genius of Scotland. Our best sons have been drained from us, our music and poetry have been degraded, and even such journals as the Edinburgh Review, founded by our own Geoffrey and Scott, are carried to London. In fact, sir, our nationality has been all but extinguished, and in violation or contempt of the Treaty of Union, we hear cabinet ministers speaking of the English government, English army, English fleet, English ministers, and other insulting terms daily used in Parliament. But so the people of Scotland want Home Rule. That, sir, is impossible for anyone to answer till they are asked. Many worthy Scotsmen do. The Convention of Royal Boroughs have so declared themselves, but I fear the bulk of the people have not thought of it. When they do, I am certain what will be their verdict. If, then, it is a desirable object, let me entreat those who can speak not to be silent in this great crisis in our history. I am, etc., Charles Waddie. Article 2 of 8, as taken from the Greenock Telegraph and Clyde Shipping Gazette, dated Wednesday, the 23rd of June, 1886. The Scottish Home Rule Association. Letter from Mr. Gladstone. The following correspondence has been forwarded to us for publication. Sir, I have the honour to bring under your notice the Scottish Home Rule Association, which, although recently formed, has already a considerable roll of members. Its object is to obtain for Scotland, while retaining undiminished her voice in the Imperial Parliament, a national legislature for the management of purely Scottish affairs. These aspirations have been for many years earnestly cherished by the Scottish people, and the proposal to grant such autonomy to the sister kingdom has their hearty sympathy. If you gave them the hope of a twin measure for Scotland, it would evoke an unparalleled enthusiasm and support. From the enclosed pamphlet, published in 1878, sent merely as a specimen of others, you will perceive that this question has long been agitated, while the enclosed publication on the Treaty of Union and the pamphlet on national and local self-government show its historical grounds. The Earl of Dalhousie, while recently referring to the Treaty of Union between England and Scotland, said that the bargain entered into by the two peoples was a fair and reasonable one, and was equally approved by both. But this is an entire mistake, as the historical introduction to the enclosed copy of the Treaty of Union will clearly show. What our ancestors desired then was a federal and not an incorporate union with England. We appeal to you as a friend of the people, the first British statesman who has embraced the great principle of Home Rule, and we hope that as you draw all your blood from Scotland, you will not withhold from us the aid which your great name would confer. We hope and believe that our association, as you have yourself said, will serve to help your movement on behalf of Ireland, and it would add zeal to our endeavours in that direction if you would allow us, as a proof of your sympathy, to inscribe your name on the programme of our association as its patron. Some members of committee attend daily at our offices in 5 St Andrew's Square between the hours of 2 and 3, and if you will honour them with an interview, they will be happy to wait upon you and explain further. I have the honour to be, sir, your most obedient, humble servant, Charles Waddie, Honour Secretary. Sir, I am desired by Mr. Gladstone to inform you that he must decline with thanks the proposal that he should become patron of the Scottish Home Rule Association, as, at his age, he is compelled to abstain from undertaking new obligations. He thinks also that it would be better that Scottish opinion should form itself freely on the subject, in whatever sense, without any interference on his part. I am, sir, your obedient servant, G.W. Spencer Littleton. Article 3 of 8, as taken from the Dundee Advertiser, dated Tuesday, the 2nd of November, 1886. Home Rule Meeting in Montrose. Mr. Waddie then addressed the meeting on Scotch Home Rule, dealing first with the question viewed historically. At the Treaty of Union, consummated in the first years of the 18th century, lay the root of the question that was agitating the country at the present time. The mistakes, nay, the crimes, that were then perpetrated requiring to be righted. Now, some people said that however corruptly the Union was brought about, it had been an incalculable blessing to Scotland, and had been the sole cause of her present prosperity. But looking into the real facts of the case, that was preposterous. Another argument their English friends used was that Scotland shared in the trade of the English colonies and had been enriched thereby. But this was perhaps the most impudent assertion of the whole pack of lies cast upon the page of history. The Colonial Empire was not in existence at the time of the Union. It had been built up since, and Scotland had done more than her part in raising it. Most certainly she had been a leader in the new departure of mechanical science, which had made such giant strides as almost to amount to a new creation. How came it about that this little people had had such an influence upon the destinies of the world? He attributed it to the hardy training they got in their wars with the English. Home Rule for Scotland, as it presented itself today, meant the restoration of her ancient Parliament and executive government, with such modifications as the wants of the present day suggested. They were not to be put off with a sham Parliament and government. They must have real power over the destinies of their country. Mr. Waddie then directed his remarks to the work of the Scotch Parliament would find to do in regard to laws affecting Scotland, and said that there was one question it might be expected to deal with greater wisdom than the Imperial Parliament, and that was the land question. For the ownership of land, its duties and its privileges were as different as possible in the two countries. The Scotch Parliament would command the concurrence of the Scotch people in dealing with this important and complicated question. The lecturer then examined the proposals of the leading English statesmen on the subject, and quoted from Lord Salisbury, Lord Hartington, Mr. Bright, Mr. Chamberlain, Sir George Trevelyan, and Mr. Goshen, followed with the opinions of 5 other statesmen, viz. Mr. Gladstone, Lord Rosebery, Mr. Childers, Sir W. Harcourt, and Mr. Campbell Bannerman, all of whom, in striking contrast to the former, had declared for self-government for Ireland and for Scotland when they asked for it. In conclusion, Mr. Waddie said the day had come when their country should either live or die. The breath was almost spent. Would they choose life or death for her, glory or shame, honour or disgrace, an immortal name or immortal infamy? The issue was in the hands of the people of Scotland, and he trusted they would be granted wisdom to decide. Article 4 of 8, as taken from the Dundee Courier, dated Friday the 8th of November, 1889. Mr. W. H. Smith in Scottish Affairs. Mr. Charles Waddie, Honorary Secretary of the Scottish Home Rule Association, has addressed the following letter to Mr. W. H. Smith, First Lord of the Treasury. Sir, in your speech delivered in Glasgow on the 8th current, you are reported to have quoted from the Encyclopaedia Britannica as follows. Many causes of fierce dispute arose between the two nations, among which not the least formidable were proceedings by the English Parliament for inquiring into matters which had occurred in Scotland. The Scotch estates threatened to form alliances and connections of their own, and it was obvious that nothing but their union with the Parliament of England could preserve peace between the two countries. And then, commenting upon the above, you go on to say, "It is urged that we must grant Home Rule in order that England may attain the control of her own affairs in her own Parliament. But I have shown that an English Parliament, with separate parliaments existing, might set on foot inquiries into affairs which were going on in Scotland. That authority has remained with the English Parliament." I have now to ask you to state your grounds for this assertion. Political, historical, or constitutional. We know that Edward I set up such a monstrous claim, but that the usurpation of authority got its fitting answer on the field of Bannockburn. That the English Parliament attempted to dictate to the Parliament of Scotland is well known, but they speedily repented of such audacity, and although in 1704 they passed an act entitled "An Act to Prevent the Mischiefs Arising to England from the Act of Security in Scotland," this act they were compelled to repeal at the demand of the Scots, and to apologise for their impertinent intrusion upon the liberty of a free people. If you refer to the terms of the Treaty of Union, you will find that on the 16th of January 1707, the English and Scottish Parliaments ceased to exist, and that by Article 3 a new Parliament was created in these words, that the United Kingdom of Great Britain be represented by one and the same Parliament, to be styled the Parliament of Great Britain. Now, as we entered into a union with England on terms of perfect equality for the better management of our mutual concerns, when this arrangement ceases to operate to our mutual advantage, as a free, independent, and unconquered people, we claim the right to review the terms of the contract, or to retire from it altogether should circumstances render such a proceeding expedient. You may rest assured that the Home Rule question as far as regards Scotland will not be settled by the surrender of any of our national rights, and that the English Parliament will never be permitted to interfere with any of our national concerns. But as the terms of settlement are certain to take some form of federalism, there will still remain a British Parliament, to which the English, as well as the Scotch Parliaments, will be in some things subordinate. As your attack upon the liberties of Scotsmen was openly made in the largest city in Scotland, I will send this protest to the press and to the Marquess of Lothian, as the minister entrusted with safeguarding the interests and honour of Scotland. Your obedient servant, Charles Waddie. Article 5 of 8, as taken from the Scotsman, dated Tuesday the 26th of November, 1889. Lord Rosebery in the Scottish Parliament. Sir, before the echo of Lord Rosebery's speech dies away, allow me to correct the astounding statement that the union with England was not brought about by bribery and corruption. This argument he uses to enhance the claims of Ireland to precedence over Scotland, and thus for his own party ends deliberately falsifies history. A very strange procedure for a patriotic Scottish nobleman. I give you a list of the parties bribed, and may add that the Court of Session led by the Lord Chancellor was also bribed, the Lords Ordinary getting their salaries raised from £200 a year to £500 a year. I am, etc., Charles Waddie. A list of the parties bribed to betray their country. Earl of Marchmont, £1,104 15 shillings 7 pence. Earl of Cromarty, £300. Lord Preston Hall, £200. Lord Justice Clerk, £200. Duke of Atholl, £1,000. Earl of Balcarres, £500. Earl of Dunmore, £200. Lord Anstruther, £300. Mr. Stewart of Castle Stewart, £300. Lord Elphington, £200. Lord Fraser, £100. Lord Polwarth, £50. Mr. John Campbell, £200. The Earl of Findlater, £100. Sir Kenneth Mackenzie, £100. The Earl of Glencairn, £100. The Earl of Kintore, £200. John Muir, Provost of Ayr, £100. Lord Forbes, £50. Earl of Seafield, £490. Marquess of Tweeddale, £1,000. Duke of Roxburgh, £500. Lord Elibank, £50. Lord Banff, £11. Major Cunningham, £100. To the messenger that brought down the Treaty of Union, £60. Sir William Sharp, £300. Patrick Coltrane, £25. Alex Wedderburn, £75. And to the Commissioners for Equipage and Daily Allowance, £12,325. Article 6 of 8, as taken from the Scotsman, dated Friday the 4th of April, 1890. Scottish Home Rule. Sir, Lord Rosebery last night, in reference to Scottish Home Rule, made use of these words. There is a question promoted very much to my left, the question of Scottish Home Rule. That is a question which does not altogether meet with the unanimous response of the Liberal Party, and yet it is a question of great importance and, if adopted by the Liberal Party, would become a question of extraordinary importance. The only meaning that can be put in these words is that, as far as the leaders are concerned, Home Rule for Scotland has no place in their programme. This is exactly what we have been saying all along, and have come in for no little abuse for daring to whisper such a sentiment. Home Rule for Scotland was to follow Home Rule for Ireland, and one step at a time was true policy. So said the rank and file of the party, but no responsible statesman ever endorsed such a policy. The whole burden of their speeches is, help us to give Ireland Home Rule and then we will get on with the work of the British Empire. If they mean to give Home Rule to Scotland, why can't they say so in plain terms? The matter of time will not disturb us. That is for the government of the day to determine. We never had any objections to Ireland's bill being read first, but if passed without safeguards being given to Scotland, in the present temper of the leaders, Scotland will never see Home Rule. When Ireland gets her own parliament, you lose the vote of the Irish members, even if retained in the Imperial Parliament, for Scotland never entered into a treaty of union with Ireland. It was nearly 100 years before Ireland joined Britain, and once in possession of a parliament of her own, the right of Ireland to vote on a question between England and Scotland would lapse. It is clear, then, that Scotland's only safety lies in refusing her consent to any partial settlement of this grave constitutional change that does not safeguard her national independence. Some ignorantly suppose this can't be done in one comprehensive measure, and say what would suit Ireland would not suit Scotland. This confusion of ideas springs from mistaking the measures passed by an assembly with the form of such assembly. All constitutional governments are very much alike in the machinery of Parliament, but the bills passed by each assembly are adapted to the wants of each nation. Let us suppose that 4 separate bills are needed for the United Kingdom, and that Ireland's is to be passed first. No one will object to that, provided it does not come into force until the other bills are passed. For Scotsmen to consent to any other settlement of the question would be to betray their country and be an act of wilful stupidity. I am, etc., Charles Waddie. Article 7, as taken from the Northern Ensign and Weekly Gazette, dated Tuesday the 30th of September, 1890. The Scottish Home Rule Association. The chairman said they had every reason to congratulate themselves upon the success of their movement since the conference last year. Practically the battle was won. The Liberal associations all over the country were now making Home Rule for Scotland one of the planks of their programme, and at the great National Federation of Liberal Associations, Mr Gladstone stated that in next Parliament one of the important matters would be to arrange legislation to give Home Rule to Scotland and Wales. Then, in the division in the House of Commons, they had an absolute majority in favour of Home Rule for Scotland, only 3 Liberal members voting against it. The present Tory Lord Advocate would not have spoken of taking a step backwards towards the darkness from which the country was withdrawn at the Union if he had read Sir Archibald Alison's proofs that Scotland owes much both of her prosperity and her general advancement to the wise legislation of her own Parliament. Dr. Clarke quoted from the writings of Alison to show the excellent legislation which the Scottish Parliament passed before the Union. He repeated that if the Lord Advocate had read the history of the country, he would not misrepresent her nor slander his race. Then they had been successful in elections except that of the Eyre boroughs. The seat was lost to the Liberal Party because the candidate was an Englishman who did not support Home Rule for Scotland. Finally, the chairman said that Scotch Home Rule was like the Scottish character, quiet on the surface, but strong, deep and determined. The minutes of last conference were read and adopted. Mr Waddie read the annual report which stated that Home Rule on a federal basis was rapidly making way. Mr Mitchell, Treasurer, made an appeal for more funds, on the ground that if they got Home Rule it would be a saving to Scotland of from 8 to 10 millions a year. He also suggested that there should be an honorary treasurer in every county to help him to collect subscriptions. Article 8 of 8, as taken from the Scotsman, dated Thursday the 6th of December 1894. The jurisdiction of the English courts in Scotland. Sir, I have read Mr Burnet's able letter on the above subject with the greatest interest. The attention is again drawn of our 2 complacent countrymen to a policy that is steadily being pursued by the legal profession in England, viz., to make the law of Scotland subordinate to that of England. I have been acquainted with a large number of English lawyers for over 30 years, and I cannot call to mind one who did not think it an injustice that there should be any separate code of laws in Scotland at all. The English judges simply act in accordance with the traditions of their profession. The one error Scottish defendants make over and over again is appearing in an English court at all. When served with an English writ, they should apply to the Court of Session for protection by an interdict. The protection of Scotsmen from the interference of the English courts was secured to us by the 19th Article of the Treaty of Union, and in the celebrated Orr Ewing case, this article was admitted to be a portion of international law, and was so upheld by the House of Lords. The Judgment Extension Act referred to cannot supersede the above article in the Treaty of Union, for such is not subject to review by the British Parliament, but is expressly reserved. It is high time this matter was settled once for all, and the only way to put a stop to it is for our courts to tell the English they may pass any judgments they like, but that they will refuse to enforce them. I am, etc., Charles Waddie.